Hello, Assalamu alaikum. How are you all? How are you all? So, in today's discussion, I'd like to talk about the prisoner rights, which is following in Bangladesh. You know that prisoner are those persons who are detained for a specific crime. He can be a criminal or cannot be a criminal, but no person cannot be declared as criminal without completion of the trial or the trial procedure in Bangladesh. But in the legal perspective and the legal principle in Bangladesh, criminal liability directly undergone the process of a systematic time and tenure. This is called the trial procedure in Bangladesh. According to Article 35 of Bangladesh Constitution, Bangladesh government will follow the absolute fair trial procedure, and whether the people, the concerned authority, they will establish the justice despite legal barriers and legal problems. So, from this perspective, criminal have some authentic right according to the Bangladesh Constitution and the legal practice and the customary norms. So, who is actually the criminal? So actually, a person will be counted as the criminal after the declaration of the court procedure or the court structure. Without the declaration of the court or commencement of the trial procedure doesn't indicate he will actually criminal or not. Whenever the judge will observe the matter after hearing that both parties, after hearing the concerned parties, witness, and the interested parties, then the court has the right to declare that he is the criminal or not. But in our legal practice, not only the legal practice, but also in the newspaper, the journalist used to say that they are the criminal, but they all not are the criminal. They can be introduced as the offender, and offender will count as the criminal only this time whenever the court declaration has been achieved by the concerned authority. So, from this perspective, the humanitarian ground definitely possess some of the rights and regulations of the prisoners. So, in the year 1980 or more than before 1980, there was a actual law. The law's name is Nelson Mandela Course. By the Nelson Mandela Course, there are three things has been achieved for the criminals who are existing in the prison. First of all, we have to ensure the human right of the criminal because all person they are related the human dignity, human liberal interpretation. So from this context, we have to observe the issue on the issues of the legal perspective and the legal analysis. Otherwise we can't say that the person is literally a criminal. The second reason is that whenever I have indicated a person he is the criminal, then I have to ensure some of the rights regulation regarding the Prisoners Act 1894 and the Prisoners Act 1900. So within this time, a practice has been organized by the practice of the different countries. They used to create the prisoners on kind of offender during the tenure of the jail. So it is not the legal practice because every prisoner has human right and some of the humanitarian rights also. First of all, he can easily get some authentic rights related to the medical treatment. That means medical treatment will be included as the fundamental right in Bangladesh. So whenever a person is in the jail, then the jail code or the jail authority have to establish the medical right of the prisoner. Otherwise, there will be not dignified the freedom of healthcare and morality. So, without any kind of problem and the legal satisfaction, we have to ensure the healthy treatment for all kinds of prisoners. The second reason is that freedom of movement is one kind of fundamental right, but it is not followed in the context of the prisoner in Bangladesh. So it is actually a legal crisis in Bangladesh. The practice is different, the legal procedure is different. For example, whenever a police officer arrested a political person and the general person, then the police officer not treated the two person same line. The reason is that the political person he actually count as the political offender, but the person who already murder a person who already raped a girl, he will be not treated as the same person as the political person in Bangladesh. We are saying there is no discrimination, but actually there are absolute discrimination that was seen in our legal practice and the jail code according to 1894. So we have to come up from the legal dispute and the legal perspective for our realization that the prisoner has some legal right, has some fundamental right, and has some humanitarian right in their legal context. For example, according to Article 35, Sub-Article 5 in Bangladesh Constitution, no person cannot be treated the subject to inhuman torture. That means we have to treat the prisoners from the humanitarian ground, and we have no right to say a person he is a criminal without the grounded right from the high court division or the lower court division. And with the common people, we are not concerned about the matter, but the legal practitioner, legal assumption have to be ensured these types of social discapability in our common practice. Otherwise we can't achieve the proper justice in that context. So the question may arise how we can ensure the legal perspective, how we can ensure the legal philosophy related to the rights of the prisoner in Bangladesh. First of all, we have to ensure the legal access for all kinds of prisoners in Bangladesh. For example, he will get the rights of the parole. He will get some of the rights of the bail petition. This is the codified right and regulation directed by our government and the legal practice in Bangladesh. The second reason is that he has the right to get the family reunification. He is the prisoner doesn't mean he will stay single for forever. So in America, in Pakistan, in Sweden, in most of the countries, the prisoner has some right to get the family reunification as a fundamental right. But actually this proposition it is not possible in Bangladesh because we have economical shackle and the economical independency. For these reasons we are not able to implement the prisoner rights for the common people, for the authentic concerned authority. So this is one kind of legal barrier of Bangladesh. So it is high time we have changed our philosophy and we have changed our rational activities for the development of the prisoner rights in Bangladesh. But I think that after 5th August, there are lots of prisoners who is detained legally or illegally, who is detained with warrant of arrest or without warrant of arrest, who is right now in prison. That means his trial procedure is ongoing in the court procedure, in the high court division, in the court division. So definitely the government, actually the jail court officer, they have to look after the issues cautiously and effectively, because this is the rational part of providing and ensuring justice in the concept of the human rights and fundamental policy in Bangladesh. So the question may arise how we can implement fundamental rights for the prisoners. I think that the Bangladeshi government they have to much more cautious about the issues to implement the fundamental rights: freedom of movement, freedom of religion, freedom of thought, conscience, freedom of education, freedom of food, and right to food, right to healthcare for the prisoners. And by giving these types of elements, by providing these types of rights with a very short time, they will achieve some of the sustainable rights. And by this way, Nelson Mandela Code has been achieved, and our jail code system of 1894 and 1900 will also be achieved in Bangladesh. And as a legal professional, I will propose to the government we have to reform the Jail Code Act 1894, because this is so primitive and not rational for the perspective of the prisoner rights and practice in Bangladesh. Even not only the common people but also the individual authority, NGOs, social stakeholders, non-state actors, they have to come forward to implement the Prisoners Act 1900, because you know that it is not the concern of the government to establish all kinds of fundamental rights and fundamental principles in the light of freedom of expression, in the light of freedom of movement or right to life, because right to life is a very good doctrine whether all kinds of people they will ensure their dignity. So though this person can be a criminal, but we have to ensure the social dignity and the political dignity for the ends of justice. And by providing these types of essential rights, we will achieve the international standard, which has been directed by international convention in different situation in different times. And I believe that Bangladeshi government will take the strategy for the development, for the sustainable ritualment of the prisoners in Bangladesh, because after observing the prisoners activities and prisoners lifestyle, I would like to say that they are leading a very bad lifestyle in the prison and during the time of condemned cell. So I urge the request to the present government to take effective initiative to make legal and moral analysis over the matter and to reduce the social problem which has been taken in the prisoners in Bangladesh. Thank you. In the next episode, I will disclose another matter, inshallah.